Hello. Today from Group 4, we have decided to pick the topic of the role of Sunnah as a source of Islamic law, understanding its relationship to the Quran. I will be touching on the part of the introduction. So firstly, let's dive into the definition. Sunnah refers to the practices, teachings, and examples set by Prophet Muhammad. In Islamic jurisprudence, the Sunnah holds a crucial position along the Quran, serving as a primary source of guidance for Muslims. While the Quran is viewed as the literal word of God, the Sunnah embodies the practical application of its teaching, illustrating how these principles can be realized in everyday life. The literal definition states that it is a clear path or an established course of conduct, whereas, based on ulama usul fiqh, it is a source of the Sharia and a legal proof next to the Quran. Let's move on to the significance of Sunnah. The Sunnah is significant as it provides context and clarity to the Quran verses, helping to elucidate their meanings and applications. For instance, while the Quran may command prayer, the Sunnah details how to perform the prayers correctly. Next, the Sunnah also is considered the second source of Islamic law, which is the Sharia, after the Quran. It offers directives on various aspects of life, including worship, ethics, and social interactions, thereby shaping the legal framework of Islamic jurisprudence. Finally, the actions of the Prophet serve as a model for ethical conduct, encouraging Muslims to embody virtues such as honesty, compassion, and justice. Talk about the types of Sunnah. There are mainly three categories of Sunnah, each with distinct characteristics and implications. Firstly, let's talk about Sunnah Qawliya, which is the sayings. It is the verbal teachings and sayings of the Prophet. For example, his statements regarding the importance of prayer or charity are classified as Sunnah Qawliya. These sayings are often recorded in hadith literature, which serves as a vital resource for understanding Islamic teachings. A noteworthy saying by Prophet Muhammad that was considered as Sunnah would be, "Livestock is liable to zakat." In this context, livestock refers to animals such as goat, sheep, or cows. Next, we have Sunnah Filia, which is action, which means the actions performed by Prophet Muhammad. These actions serve as practical demonstrations of the Quranic injunctions. For instance, the specific movements and recitations during Salah, which is prayer, the manner in which he observed fasting during Ramadan, or his interaction with others exemplifies Sunnah Filia. By observing the Prophet's actions, Muslims gain a model for personal conduct, promoting consistency between belief and practice. Finally, we have Sunnah Takririya, which is approval, which embodies the actions of others that the Prophet Muhammad witnessed and did not object to, thereby signifying his approval. This highlights the permissibility of certain actions within Islamic law. The Prophet's silence or acceptance of certain actions indicates they are permissible in Islam. For example, when a companion performs a specific act of worship or engages in a social practice without objection from the Prophet, it implies that such behavior is acceptable. The significance of Sunnah Takririya is that it allows room for adaptation and interpretation in legal rulings, acknowledging the diversity of cultural practices as long as they do not contradict with Islamic principles. It helps understand how the community of believers functioned during the Prophet's time, providing insights into acceptable social norms. Okay, so now we're going to talk about the objectives. There are three main objectives to this assignment. The first one is to analyze the legislative function of the Sunnah in conjunction with the Quran. The second one is examine the methodology frameworks employed to understand and harmonize the Quran and Sunnah. And the last one is to investigate the influence of this connection on Islamic jurisprudence and its capacity to adapt to modern concerns. That is all from me. I'm passing on to the next presenter. Thank you.
I would like to explain about the overview of a key scholar, who is Imam Al-Shafi'i, who is a scholar in Islamic legal theory, and his work has played a key role in solidifying the authority of the Sunnah, and it is within the Islamic law. And let's take a closer look at his contribution and he has given to the society. And he is pioneering the legal theory. Shafi'i is best known for his groundbreaking the book Kitab Al-Risalah, which is considered the first organized study of Islamic legal principle or Usul al-Fiqh. In this work, he established the Quran and the Sunnah as the primary sources of Islamic law. And second is role of Sunnah. Shafi'i highlighted the critical role of Sunnah, which is clarifying and implementing the Quran's guidance. For example, the Quran instructs Muslims to pray, but the Sunnah provides exactly the method and how to perform the Salah. And he emphasized that the Sunnah complement the Quran, ensuring the divine guidance is practical and applicable. And the third point is authentication of hadith. To maintain the integrity of Islamic law, Shafi'i established strict criteria for accepting hadith. He insisted on accuracy, reliability, and unbroken chains of transmission. ensuring that only authentic prophetic tradition were used in legal rulings. And the fourth point is integration of Quran and Sunnah. Shafi view the Quran and Sunnah as the unified legal framework. The Quran offers broad principles, while the Sunnah provides detailed and practical implications. And this approach bridges the gap between textual guidelines and real-life implementation. And the last point is legacy in Islamic jurisprudence. Finally, Imam Shafi's methodology combines textual evidence with logical reasoning, such as qiyas or analogical deduction. His systematic approach influenced many schools of Islamic law, and his effort ensured that the Islamic law remained adaptable to the evolving needs of Muslims.
Next, the examination of classical and modern perspective on the role of the Sunnah. The Sunnah has been analyzed extensively from both traditional and modern perspective, showing its evolving role in Islamic law and practice. Traditionally, the Sunnah is considered as a primary source of Islamic law, second only to the Quran. While the Quran provides broad spiritual guidance, it often requires the Sunnah to clarify and contextualize its teaching, especially on social, legal, and ethical issues. This is reflected in the saying, Al-Quran al-Waj ila Sunnah min al-Sunnah ila Al-Quran. The Quran needs the Sunnah more than the Sunnah needs the Quran. In early Islamic, though, the concept of the Sunnah was broad and adaptable, focusing on the ethical, legal, and practical examples set by the Prophet Muhammad. It was primarily passed down orally, without being limited to written records. Over time, as Islamic law developed, Sunnah became closely tied to the Hadith, defined as the Prophet saying, action, and approvals recorded in verified collection. This shift, called the Hadith-dependent Sunnah, introduced a more structured and legalistic approach. Contemporary scholars often question this traditional link between Sunnah and Hadith, arguing it limits the broader dynamic nature of the Prophet. Example, thinkers like Adis Tutarija suggest that in the pre-classical era, Sunnah operated independently of Hadith, emphasizing moral, ethical, and legal flexibility. Today, many interpretations aim to align Sunnah with modern issues like pluralism, coexistence, and justice, highlighting its adaptability to evolving societal needs. The Prophet role as Uswah Hasanah is being re-evaluated to address modern issues like interfaith, harmony, and ethical governance. This highlights the universal principle of compassion, tolerance, and justice that go beyond historical and cultural boundaries. While classical views focus on legal precision, modern interpretation emphasize moral and ethical flexibility, showing the Sunnah and the relevance in guiding both individual and collective lives. This blend of perspective enriches Islamic thought, offering a comprehensive understanding of the Prophet legacy as both a legal and ethical model.
Greetings and good day, Doctor. My name is Priyadashni Iswaran. My matrix ID is 078008, and I will be explaining on the case studies regarding on how Quranic verses and the Sunnah is in the contemporary Islamic world. So we're going to explore about how specific Quranic verses interpreted alongside with the Sunnah in the contemporary Islamic world. So for this, we took 4 cases, which in 2 cases from Malaysia itself and 2 cases in the international scope. So the first case is in the international scope, wherein women's inheritance in Tunisia. So in Tunisia, the Tunisia Personal Status Code 1956 expanded women's inheritance rights, moving beyond the traditional interpretation of Surah Al-Nisa for Clause 11, which prescribes that men inherited twice the share of women. The traditional approach reflected on the socio-economic norms of the past, where men were the primary providers. Tunisian reforms consider both the Quran and the Sunnah to emphasize justice and equity in the light of changing societal norms. They acknowledge in the Prophet Muhammad's promotion of fairness using Sunnah to adapt Islamic law to the contemporary gender equality ideas. This reform demonstrates how the Quran principles are contextualized by the Sunnah align with the modern values of justice. So for the second case is that apostasy laws in Sudan. In 2022, Sudan repealed apostasy laws, reflecting a shift in interpreting Surah Al-Baqarah 2256, there shall be no compulsion in religion. While traditional interpretations of Sunnah once supported that death penalty for apostasy, modern scholars emphasize the Quranic values of freedom and human dignity. The Prophet Muhammad often chose not to punish apostasy, focusing instead on community and unity. This reform shows how the Sunnah's historical context can guide a modern application, ensuring alignment with personal freedoms and human rights. The next case will be a very own Malaysian case and one of very debated Malaysian case, which is the case of Lina Joy in Malaysia. So in the case of Lina Joy, it is highlighted in the division between civil and Sharia court in Malaysia. While Joy wanted to remove Islam for her identity card after she renounced from Islam to Christianity, her application was denied as apostasy falls under Sharia jurisdiction. Similar to the case before this, Surah Al-Baqarah 2256 emphasizes that Islam does not compel belief. However, Sunnah and Islamic jurisprudence guide the nuanced approach towards apostasy, balancing individual rights with communal obligations. This case underscores how the Quran and Sunnah work together to address complex legal issues in Malaysia with dual legal framework.
Hi, my name is Nurbatrisha binti Mohamed Ramizan with the matrix number of 078408. Today, I will be continuing where my friends have left off on the case studies that highlights on specific Quranic verses, considering the Sunnah's interpretation as well, whereby the implementation of hudud laws in Kelantan is explained. Hudud laws in Islamic law addresses crimes like theft, robbery, and even adultery, with punishments including flogging, amputation, or even death sentences. Surah Al-Ma'idah, verse 38 of the Quran mentions regarding the thief, whether male or female, cut off their hand as a punishment. However, this interpretation of this verse must consider the Sunnah of the Prophet Muhammad, which provides necessary conditions for implementing such penalties. The Sunnah, emphasizing justice and compassion, ensures punishments are applied fairly and only in specific circumstances. For example, nisab, theft must exceed a minimum value of the stolen goods. Intent, theft must be deliberately done, not driven by necessity of survival like hunger or poverty. Thirdly, due process. Punishments must require a thorough investigation, and any doubt invalidates this sentencing. Fourth, restorative justice. Victims may forgive or agree to restitution, avoiding hudud penalties. Furthermore, in Malaysia, the Kelantan Sharia Criminal Code 1993, which is amended in 2015, incorporates these principles to ensure hudud laws align with the Sunnah. This approach safeguards fairness, preventing misuse and ensuring laws reflect maqasid al-Sharia, or the higher objectives of Islamic law, which prioritize justice, compassion, and social harmony. By integrating the Sunnah, Malaysia demonstrates how Islamic laws can be applied in a modern and balanced way, adapting to evolving societal needs while also preserving core values. That is all from me on regards to case studies. I will now move on to the next presenter. This research adopts a systematic approach to analyze the legislative functions of the Sunnah in conjunction with the Quran itself. By comprising and combining primary and secondary sources, the study ensures a comprehensive yet complete understanding of this topic. Primary sources include Quran and authentic hadiths, compilations like Sahih Al-Bukhari, and Sahih Muslim, offering foundational insights into Islamic law itself. Secondary sources such as scholarly articles, legal commentaries, and books provide critical perspectives on the Quran and Sunnah relationship, bringing classical interpretations with contemporary views. Henceforth, this methodology allows for an analytical and factual exploration, ensuring a balanced understanding of how the Sunnah complements the Quran in addressing legislative aspects. Ultimately, it addresses or integrates diverse perspectives to deepen the knowledge and offer nuanced insight into the research topic. That is all from me. I will now pass to the next presenter to explain about the findings on this research.
Hi, Assalamualaikum warahmatullahi wabarakatuh, and a very good evening to everyone. My name is Nurifa binti Karisha with metric number 077220. So let me present the findings of our report. First, the Sunnah serves as a practical guide to Quranic principles. While the Quran provides broad laws, the Sunnah demonstrates how to apply them in daily life. For example, the Quran commands prayer but doesn't explain its structure. This is clarified by the Sunnah. Similarly to guiding fasting, charity, and social conduct, ensuring personal and public alignment with Quranic principles. Second, scholars like Imam Shafi'i developed frameworks to preserve and interpret the Sunnah. In his kitab Al-Risalah, he highlighted how Quran and Sunnah complement one another. He also established rigorous methods to verify hadith through isnad and the integrity of narrators while contextualizing rulings like hudud punishment. This ensures that Islamic law remains both accurate and adaptable. Finally, contemporary interpretations of the Sunnah address modern challenges. For example, the Prophet's interactions with other faiths promote interfaith tolerance. His practice of consultation or shura guides ethical governance, and his emphasis on compassion and zakat supports social justice. This shows that the Sunnah remains relevant and adaptable to evolving societal needs. The Quran serves as the ultimate divine revelation, while the Sunnah shows us how to apply its teachings in daily life. Together, they have shaped legal interpretations throughout history. However, the application of the Sunnah has evolved, influenced by societal norms and legal frameworks, as seen in case studies like women inheritance in Tunisia, apostasy laws in Sudan, and hudud laws in Malaysia. In Tunisia, Surah An-Nisa verse 11 states that men inherit twice than what women do. But reforms have expanded women's inheritance right to reflect modern values of gender equality. These reforms are inspired by the Sunnah ethical principles of fairness and justice. In Sudan, the repeal of apostasy laws shows a shift in how the Sunnah is interpreted. While traditional views supported the death penalty of apostasy, Sudanese reformers drew from Surah Al-Baqarah, verse 256, which there is no compulsion in religion, and emphasized that the Prophet's teachings on mercy and freedom of belief. In Malaysia, the application of hudud laws highlights the importance of integrating the Quran and Sunnah. For instance, Surah Al-Ma'idah, verse 38, prescribe cutting off a thief's hand, but the Sunnah provides context, ensuring penalties are fair and applied only in cases free of hardship. The Kelantan Sharia Criminal Code incorporates these conditions, upholding justice and mercy. Overall, these examples show how the Sunnah has shifted from strict literalism to a more dynamic guide, emphasizing compassion, flexibility, and fairness. This demonstrates the enduring relevance of Uswah Hasanah, the Prophet's exemplary conduct, as a moral and ethical framework for all time and context. So in conclusion, the Quran and Sunnah are the foundation of Islamic law, with the Quran providing principles and the Sunnah offering practical guidance. Scholars like Imam Shafi'i have shown how these two sources work together to make Islamic teachings both relevant and understandable. Modern interpretation draw from the ethical lessons of the Prophet's life to address contemporary issues like social justice and gender equality. Case studies from Tunisia, Sudan, and Malaysia demonstrates how combining the Quran and Sunnah allows Islamic law to adapt to evolving societal needs while balancing tradition with modern values. That's all from our group. Thank you.